On the 2nd October of 2025, the Federal Court delivered its decision for the case of Lim Swee Choo and Ong Go Ho. Many say that it is a landmark decision. This is because it has overturned its decision in Berjaya Times Square and M Concept. Now, in this video, we will look at the facts of Berjaya Times Square, what was the decision in that case, and what was so controversial about that decision. We will then look into the facts of Lim Swee Choo and what did the Federal Court say in relation to its earlier decision in Berjaya Times Square. The subject matter of this case was the mixed development and shopping mall in the heart of KL known as the Berjaya Times Square. M Concept signed a sale and purchase agreement with Berjaya to purchase a shop lot in the project. According to the SPA, Berjaya shall deliver vacant possession to M Concept on or before the 23rd of November 1998. If it fails to do so, they would be liable to pay liquidated damages. Like most SPA, it also contains a clause stating that time is of the essence. Who are old enough to remember will recall that the project, like many others during the Asian financial crisis, had suffered delay. Berjaya did not deliver vacant possession on the 23rd of November 1998 as promised under the SPA. At that time, M Concept did not terminate the SPA. Instead, they continued to make further progress payments. In fact, they paid the purchase price in full. To the benefit of Berjaya, they had kept the purchases informed of the delay. They had informed M Concept that they would deliver the shop lot by the end of 2002. That too did not happen. M Concept finally filed an action in court. They prayed for a declaration that the SPA has been rescinded and for the refund of the purchase price it had paid. They also claimed for other damages. The High Court decided in favor of M Concept. This was affirmed in the Court of Appeal. However, when it reached the Federal Court, the decision was reversed. The Federal Court dissected the elements necessary to make a finding. The late Justice Gopal Sri Ram began by postulating, at the heart of this appeal lies the question, what are the rights of an innocent party where there is a breach of contract? Of course, not every single breach of the terms of a contract will amount to a repudiation. The law requires that in order to amount to a repudiation, the breach must, quote-unquote, go to the root of the contract. In other cases, the court have used different phrases like fundamental breach or serious breach. He continues, the only issue that remains is whether, as held by the learned trial judge, the respondent as the innocent party is entitled to rescind the contract. That is to say, to have the parties restored to a position where they stand as if the contract has never been made. He then goes on to state that the law as to what happens when a contract is terminated. The doctrine of repudiation is based on the proposition that where a promisor wrongfully repudiates a contract in its entirety, the promisee has a choice. He or she may elect to accept the repudiation, treat the contract as at an end, and sue for damages. Now, those who are familiar with the law understands this basic proposition, where a person has breached the contract, and where the breach goes to the root of the contract, that person is described as having repudiated the contract. The innocent party then has a choice. He can disregard the repudiation and continue with the contract, or he can accept the repudiation and bring the contract to an end. This is commonly described as rescission or a right to rescind. The problem here is with the word rescission because it carries another different meaning. This is what the late Justice Gopal Sri Ram said. But this rescission is very different from the specific relief of rescission invented by the Court of Chancery. The right to terminate puts an end to the contract only as to the future. All past rights and duties under the contract remain unaffected. But that is not the case where the equitable remedy of rescission is obtained by a decree from the court or by self-help. The second word of the word rescission does not equate to termination. It has to do with the remedy or powers of the court to restore a person to the original position. But this remedy does not apply in every situation where there is a breach of contract. As rightly decided in Berjaya Times Square, the hallmark of equitable remedy of rescission is that it is only available to set aside contracts that are voidable by reason of the ingredient of free consent, which is sine qua non in the making of the contract, having been vitiated by the element external to the contract. Examples of elements that vitiate free consent are fraud, misrepresentation, duress, undue influence, and breach of fiduciary duty. Whether a court of equity will set aside a contract that is void for common mistake, which is the element that does not vitiate consent, is one that is debatable. That said, it is now settled that there is common law, a right to rescind a contract in very limited circumstances. It was on that basis that the federal court found for the developer. Had the purchaser merely sued for liquidated damages, the outcome may have been completely different. But when they sought for the refund of all the monies they had paid, that amounted to restoring them in a position prior to entry of the SPA. The court held that for that remedy for restitution, it is not available to them as there was no total failure of consideration by the developer. It is unfortunate that the word restitution has two meanings and that both meanings are applicable to this very case. Yet, from the analysis above, it would appear that the ratio of the federal court was sound, as there appears to be quite clear distinction between both uses of the word. However, the problem was that in the same judgment, it contained this paragraph. A reference to Section 40 and Section 56(1) of the Act clearly showed that the right to rescind a contract by way of termination only arises where there has been a total failure of consideration. Now, why is this an issue? It is because Section 40 and Section 56 of the Contracts Act concerns not repudiation in the remedy sense, but in the sense of the breach of termination in the first meaning of the word. The heading on Section 40 reads, effect of refusal of a party to perform promise wholly. Now, Section 40 says this: when a party to a contract has refused to perform or disable himself from performing his promise in its entirety, the promisee may put an end to the contract unless he has signified by words or conduct in his acquiescence in its continuance. In fact, Section 40 has two illustrations as to how this proviso applies. Now, at illustration B, it says this: A singer enters into a contract with B, the manager, to a theatre, to sing in his theatre 2 nights in every week during the next 2 months. And B engages to pay her at the rate of 100 ringgit for each night. Now, on the 6th night, A willfully absents herself. With the assent of B, A sings for the 7th night. B had signified his acquiescence in the continuance of the contract and cannot now put an end to it, but is entitled to compensation for the damage sustained by him, though A's failure to sing on the 6th night. Even the illustration clearly provides that you can recover only damages on the 6th night, which the singer was willfully absent. It does not provide for recovery of all the monies paid. From that sentence, it appears the federal court is now saying that in order to rescind a contract or bring a contract to an end as a result of breach, there must first be a total failure of consideration. And that is incorrect. Now, this is where the mix-up happens, and sadly enough, it was applied in many cases after the decision of Berjaya Times Square. This is why the case of Lim Swee Choo is so crucial to clear up the misconception from the decision in Berjaya Times Square. The facts of Lim Swee Choo is convoluted, to say the least. The federal court, in fact, has labelled them as not entirely straightforward. Well, let's see if we can explain the facts of this case as if to a 5-year-old. On the 26th of June 2015, Lim Swee Choo and another, who we shall refer collectively as the plaintiffs, entered into a sales and purchase agreement with DA Land to purchase 4 pieces of land in Rawang. We shall refer to DA Land as the landowner. The purchase price was for 23 million ringgit. Out of the 4 lots, one of the lots has a caveat lodged by one Ho Fook Cheo. Under the SPA, the landowner promised to remove the caveat. On the 20th of October 2015, the plaintiffs then entered into an agreement with Ong Koh Hao, which we will refer to as the defendant. This agreement says that the plaintiff will assign absolutely the rights in all the 4 lots to the defendant for the price of, 25.5 million ringgit. How this 25.5 million ringgit was to be paid is as follows. Number 1, the sum of 20 million ringgit for the purchase price paid by the plaintiff to the landowner under the SPA shall be set off against the first plaintiff's debt owing to the defendant. It appears that the plaintiff has been owing the sum of 20 million ringgit to the defendant since 2013. B, the balance of 3 million shall be paid directly to the plaintiffs. And C, a balance of 2.5 million ringgit shall be treated as the plaintiff's investment in the 4 lots representing 4.5% of the value of the lands. Let's call this the assignment agreement. The plaintiffs and the defendant then agreed that the 4 lots of land will be transferred directly from the landowner to the defendant. It says, upon the execution of this agreement, the first party shall forthwith nominate the second party as the transferee of the said land and shall ensure that the second party shall be entitled to execute the relevant memorandums of transfer as the transferee of the said land without any objections or obstruction from DA Land or any third party. So, in a gist, the plaintiff offered to buy up 4 parcels of land from the landowner for 23 million. He then proceeds to assign and, quote, sell those 4 parcels of land to the defendant via an assignment, upping the sale price to 25.5 million ringgit. Now, if at this point this whole arrangement seems a bit odd to any of you, well, you are not exactly wrong. But hang on, as things are about to get even more bizarre. Now, on the 17th of December 2015, the landowner filed a suit against the plaintiffs. This led to the parties entering into a consent judgment dated the 2nd of June 2016, where the plaintiffs admitted that they had no right, claim, or caveatable interest over the 4 lots of land. While that case was ongoing and unbeknownst to the plaintiffs, on the 24th of May 2016, the defendant had entered into an SPA with the landowner for the purchase of 3 out of the 4 lots of land from the landowner, and for a whopping price of 85.5 million ringgit. That is close to 3.5 times of the value between the plaintiff and the defendant, but for only 3/4 of the original lands. According to the defendant, he had entered into the SPA with the landowner on the 1st of October 2015. He then claims that the parties had signed 2 separate supplemental agreements, one dated the 3rd of October 2014 and another on the 29th of October 2015. The defendant relies on the wordings inside the 2 supplemental agreements, which states that he had already paid 51 million ringgit out of the 85.5 million purchase price. Save and accept that the deposit and the accelerated payment paid by the purchaser to the vendor now stands at 51 million ringgit only, and the balance purchase price of the said property is 33 million ringgit only. All the other terms and conditions of the SPA shall remain unchanged and in full force, thereby leaving only 33 million ringgit of balance purchase price to be paid. He then claims to have made a final payment of 10 million ringgit on the 29th of October 2015, thereby reducing the balance to only 23 million ringgit. The defendant then said he had activated clauses 4.1 and 4.2 under the SPA, which allows for him to terminate the sale and purchase simply by notice, and therefore demand a refund from the landowner for the 61 million ringgit he had paid thus far. Clause 4.1 reads, notwithstanding anything contained in this agreement but subject to section 5 and 6 herein, the parties hereto agree that the purchaser shall not be entitled to complete this agreement before the 30th of September 2016. After the expiry of the said cooling off period, the purchaser shall notify the vendor in writing of its intention to proceed or otherwise with this agreement. Clause 4.2 says that in event the purchasers elect to terminate this agreement, the vendors shall within 10 days of the said notice of termination refund to the purchaser's deposit and all monies paid by the purchasers, failing which the purchaser shall be absolutely entitled to proceed with the completion of the agreement, and the said notice of termination shall be deemed automatically revoked and of no effect. Thus, the defendant filed an action against the landowner, claiming, for among others, the refund of the 63 million ringgit he had allegedly paid to the landowner. The landowner disputes the defendant's version of events. They say that all the documents, the SPA and the 2 supplementary agreements, they were all in fact executed on the same day, which is on the 24th of May 2016, and were all backdated. Except for the 23 million, which was paid via the earlier transaction by the defendant to the plaintiff, the landowner denies that the defendant had made any further payments towards the purchase sum. According to the landowner, the rest of the payments alleged in the 2 supplementary agreements relate to monies which the defendant lent to various companies which were owned by the directors of the landowner, DA Land. Since the defendant did not have a money lending license, these payments would be in contravention of the Moneylenders Act of 1951 and would be void for illegality. The court agreed with the landowner's version of the facts. The court said, on the face of these 3 documents, the illusion created is that the SPA was executed on the 1st of October 2015, and then subsequently part payment of the 25.5 million ringgit was made on the 3rd November 2015, and another part payment of 10 million ringgit was made on the 29th September 2015. Nevertheless, from the defendant or purchaser's own witness, SD1, during re-examination had confirmed that all the 3 agreements were executed on the same day, and that, as far as she was aware, no actual payment was made. Furthermore, the defendant or purchaser has produced no evidence whatsoever to discharge this burden in rebutting the allegation that no monies were paid to DA Land. From the witnesses' testimonies, it is my conclusion that it became clear that the defendant purchaser had developed a mechanism of lending money with property held as security against various third parties, including companies of which Derek and Howard were directors. The defendant purchasers had knowledge that all the transactions took the form of sale and purchase agreement. It also followed that in each instance, the vendor plaintiff was making payments to the defendant purchaser in the form of post-dated check issued in the defendant or purchaser's favor. This highly unusual nature of these transactions failed to be explained by the defendant when questions were put to him during cross-examination. There are documents bearing the defendant's signature which clearly states that the transaction listed involved payments of principal sums and their charges of interest. On the issue of post-dated checks, though the defendant submits that since the checks were dishonored, there is no evidence of interest being paid or collected and hence not a moneylender. Nevertheless, to my mind, the defendant does not explain in any way the nature and purpose of the payments being made via the post-dated checks. The cumulative effect of all the above evidences, which remains unchallenged to my mind, the defendant purchaser is in the business of money lending within the meaning of the Moneylenders Act 1951 cannot be ruled out. That being said, pursuant to Section 5 of the said Act, the defendant purchaser is required to be licensed in order to carry on the business of money lending. No such license having been tendered in evidence, it must be taken that the defendant purchaser is an unlicensed money lender and that the supplementary agreements 1 and 2 are tainted by these illegal activities. Following this, the defendant's claim for the refund of the 61 million ringgit part payment was dismissed, and the landowner was allowed to forfeit the deposit of 23 million ringgit. The defendant appealed against the High Court's decision, but this was dismissed by the Court of Appeal. On the 22nd of July 2020, leave to appeal to the Court of Appeal was dismissed. Thereby, the defendant's case against the landowner had reached the end of its proverbial road. And just when the dust was settling between the landowner and the defendant, on the 15th of June 2020, the plaintiff filed an action against the defendant. The plaintiff sued for breach of assignment agreement and the supplemental assignment agreement and claims for the loss of the 2.5 million ringgit, the very same 2.5 million ringgit which would account as the plaintiff's investment into the lands under the said agreements. The plaintiff's case is that the defendant had entered into a separate SPA with the landowners. Remember the SPA for the 85.5 million ringgit to purchase 3 out of 4 parcels of land? That very same one. By entering into the SPA, the plaintiff contends that the defendant had breached the assignment agreement and as a result, his 2.5 million ringgit investment was diminished. As if taking a page off from the landowner's playbook, the defendant now says that the SPA between the plaintiff and the landowner is tainted with illegality as it constituted an illegal money lending transaction where all 4 lands were used as collateral for money lending transactions between the plaintiff and the landowner. If that was true, that would mean that the plaintiff had no power to enter or to assign any rights under the SPA and that the assignment agreement and the supplemental assignment agreement would fall as well. At least that was the defendant's case. On top of the illegality, the defendant also said that they were deceived by the plaintiff because they were not made aware of the caveat to one of the 4 lands. So long as the caveat remains, the defendant says that the assignment could not be completed. The defendant argues that as the assignment agreement cannot be completed, there was a total failure of consideration by the plaintiff and therefore the defendant should be entitled to recover the 33 million ringgit which he has paid. After 4 days of trial and another 2 days of clarification, the High Court delivered its decision. Dismissing the defendant's counterclaim, the London High Court judge held that there was no evidence to support the defendant's case that the SPA was tainted by illegality. However, the plaintiff's claim was also dismissed. One of the reasons was that the learned judge in the High Court found that the defendant had not breached the assignment agreement. Both parties appealed to the Court of Appeal. Now, at the Court of Appeal, this was the court's finding. Number 1, agreeing with the High Court judge, the Court of Appeal held that the defendant had failed to prove that the SPA between the plaintiff and the landowner was tainted with illegality. So that deals with the issue of illegality. Number 2, as for the total failure of consideration, this is what the Court of Appeal said. Firstly, it is not disputed in this case that the defendant had paid 23 million ringgit to the plaintiffs pursuant to the assignment and supplemental agreement. In consideration for the defendant's payment, the plaintiffs agreed to assign absolutely their rights in the 4 lots to the defendant under the assignment and supplemental agreement. It is clear that there was a total failure of consideration due to the following reasons. Number 1, according to para 3 Roman 2a of the consent judgment and settlement agreement in the other suit, the plaintiffs had no right, claim, or capable interest in the 4 lots. The plaintiffs cannot now dispute the contents of the said para 3 Roman 2a of the consent judgment and settlement agreement. Accordingly, the plaintiffs were not in a position to assign absolutely any interest or rights in the 4 lots to the defendant under the assignment or supplemental agreement. The plaintiffs have not satisfied to us that the High Court's finding of this fact is plainly wrong. In view of the sale, the plaintiffs could not assign absolutely their rights and interests in one of the lots to the defendant pursuant to the assignment and supplemental agreement. When there is a total failure of consideration of an agreement, equity may bar a party from enforcing any right provided in the agreement when the enforcement of such a right is unconscionable. We rely on the following judgment of the High Court of Australia in Roxburgh against Rothmans of Pall Mall, Australia. Premised on the above judgment by Justice Gamau in Roxburgh, in view of the total failure of consideration in the case, it is unconscionable for the plaintiffs to rely on the assignment and supplemental agreement to claim for a sum of 2.5 million ringgit from the defendant. In fact, as found in the High Court's first actual finding, the plaintiffs had actual knowledge of the sale of the land. With such knowledge, the plaintiffs should not have entered into the assignment and supplemental agreement in the first place. If the original action is allowed, the plaintiffs would be unjustly enriched in a sum of 2.5 million ringgit when the plaintiffs cannot assign absolutely any right or interest in the 4 lots to the defendant under the assignment and supplemental agreement. Thus, the Court of Appeal affirmed the decision of the High Court judge to dismiss the plaintiff's claim for the 2.5 million ringgit loss. As for the defendant's counterclaim for the return of the purchase price of 23 million ringgit, the Court of Appeal overturned the High Court's decision and allowed the defendant's counterclaim. Now, this is what the Court of Appeal held. We have no doubt that in view of the total failure of consideration in this case, the High Court should have applied the restitutionary basis and ordered the plaintiffs to return the 23 million ringgit to the defendant. Such a failure on part of the learned High Court judge was tantamount to a legal error which A, had caused an injustice to the defendant, and B, warrants appellate intervention on our part. According to the High Court's fourth factual finding, the defendant's loss in this case was caused by the defendant's own greed. With respect, we are unable to agree because irrespective of the defendant's greed or altruism, by operation of case law, for example, Goh Yew Chew, the learned High Court judge should have applied the restitutionary basis and ordered the plaintiffs to return the 23 million ringgit to the defendant. Thus, we now come to the Federal Court. On the issue of illegality of the SPA between the plaintiff and the landowner, the Federal Court agreed with the findings of both the High Court and the Court of Appeal in that learned panel correctly applied the law in concluding that there was no evidence of illegality in the plaintiff's SPA with the landowner. The defendant has failed to discharge the burden of proof to establish that the SPA contravened the Moneylenders Act of 1951 or that the assignment and supplemental assignment agreement was tainted with illegality arising from the alleged contravention. We agree with their lordship's finding and we shall refrain from further analysis of the evidence and findings thereon. In our judgment, the plaintiff's SPA with DA Land dated the 23rd of June 2015 and the assignment agreement dated the 20th of October 2015 and the undated supplemental assignment agreement both entered into between the plaintiffs and the defendant are valid and enforceable. So far, so good. The Federal Court agreed that the SPA between the landowner and the plaintiff was valid and not tainted with illegality. However, things then took a surprising turn. Remember the SPA that was entered between the defendant and the landowner for 3 out of the 4 parcels of land? The one for the whooping 85.5 million ringgit? Yeah, that one. Well, this is what the Federal Court held. The same, however, cannot be said of the defendant's SPA with DA Land. As evident from the Shah Alam High Court judgment in suits 396 and 88, of which we shall take judicial notice, the defendant's SPA was declared void for illegality and uncertainty. Given the doctrine of restitution based on total failure of consideration is an equitable principle, we must direct our focus to the conduct of the defendant before we can determine whether he has come with clean hands and is entitled to recover the 23 million ringgit from the plaintiffs through the conscience of this court. For a start, we, however, cannot help but question the position taken by the defendant. If the assignment agreement and the supplemental assignment agreement were indeed void for illegality as asserted by the defendant, though they are not, the loss would lie where it falls. In that event, it is difficult to see how the defendant's claim over the 23 million ringgit could be sustained. The federal court then cited former Chief Judge of Sabah and Sarawak, Justice Abdul Rahman Sebli, in Triple Zest Trading and Supply Syndrome Berhad and Applied Business Technology Syndrome Berhad, where his lordship held. This not only goes against the object of MA 51, which is for, quote, the regulation and control of the business of money lending, the protection of borrowers of monies lent in the business and matters connected therewith, but it is also against the tried principle that loss lies where it falls when an agreement is found to be illegal. Meaning to say that there is an established principle in law that where an agreement is tainted with illegality, the court will not lend its hand. Thus, since the defendant is now saying that the assignment agreement is void for illegality, then the loss should lie where it falls, and the defendant should not be allowed to recover the monies from the defendant. But the federal court did not stop there. It also took judicial notice of the decision of the suit between the landowner and the defendant, which, if you recall, the court held that the transaction was tainted with illegality. And since the consideration in this suit, i.e. the 23 million ringgit, is the very same subject matter as the deposits that was forfeited in the landowner and defendant suit. Therefore, in now considered view, this shows that the forfeiture was enforced as a legal consequence of the SPA, regardless of whether the deposit had been fully paid in the conventional sense. In other words, what was forfeited was the defendant's contractual right to claim the 23 million ringgit deposit from DA Land rather than any actual transfer of funds. In our judgment, the 23 million ringgit purportedly paid by the defendant to DA Land is not a separate and distinct amount, but in reality relates to the same 23 million ringgit paid to the plaintiffs. Looking at the transactions, contracts and supporting documents within the appeal records and as a whole, we are unable to comprehend or appreciate the defendant's overall case and conduct in any other light than that he had wrongfully reapplied and utilized the sum of 23 million ringgit in his transaction with DA Land, which was subsequently found to constitute an illegal money lending arrangement and ultimately forfeited by DA Land as evident from the Shah Alam High Court judgment in suits 396 and 88. To our mind, the defendant is the architect of his own loss and misfortune by his subsequent unilateral dealing with DA Land. The plaintiffs, however, were not involved in the defendant's subsequent SPA with DA Land, which was done without their knowledge. What the defendant is effectively attempting to do now is to recover the same sum of 23 million ringgit through a different route and by invoking a purported new cause of action. It would be manifestly unconscionable for the defendant to claim for restitution of the amount against the plaintiffs, more so on monies that the defendant himself had not paid. Equity will not permit the defendant to reclaim the amount from the plaintiffs on ground of total failure of consideration. In the premises, the defendant's unconscionable conduct bars his claims for restitution and unjust enrichment. In our considered view, that which cannot be done directly cannot be achieved indirectly. Thus elucidated, the defendant is not entitled to pursue recovery on the basis of the equitable doctrine of total failure of the consideration from the plaintiffs the amount of 23 million ringgit, which amount had previously been declared by the High Court in suits 396 and 88 as non-recoverable because it comprised part of an illegal money lending transaction engaged in by the defendant and in which proceedings the defendant was declared an unlicensed money lender. Similarly, the defendant is not entitled to pursue recovery on the same equitable principle for the same amount when the defendant was found by the High Court in the main suit from which the present appeals originate as the party who had caused the loss and on which loss he had based his claim of a total failure of consideration. In this regard, we agree with the submissions by the learned counsel for the plaintiff. Given the background, the Court of Appeal could not, in equity, order the plaintiffs to refund the 23 million ringgit to the defendant. The Court of Appeal's failure to give consideration to A, the relevant surrounding circumstance of the defendant's use of the 23 million ringgit in subsequent unilateral transaction with DA Land for Rabang 3 after having entered into the assignment agreement and supplemental assignment agreement with the plaintiffs for Rabang 4, and B, the effects of the Shah Alam High Court judgment in suits 396 and 88 on the defendant constitutes a fatal misdirection warranting appellate intervention. As for the plaintiff's claim for the 2.5 million ringgit which was dismissed by the High Court and affirmed by the Court of Appeal, this is what the Federal Court said. The Court of Appeal dismissed the plaintiff's claim on the ground that it was unconscionable to allow the plaintiffs to claim the 2.5 million ringgit from the defendant. As we now find that there is no total failure of consideration and there was no basis for the Court of Appeal to make a finding of unconscionability against the plaintiffs, we are of the considered view that the defendant had breached the assignment agreement by entering into the SPA with DA Land for Rabang 3, which the Shah Alam High Court in suits 396 and 88 later held to be an illegal money lending transactions and thus unenforceable, and which, in turn, resulted in the defendant losing all rights, interests, and title to the lands in Rabang 3, without which Rabang 4 could not exist. Through the aforesaid actions, the defendant had deprived the plaintiffs of the benefits they were entitled to as consideration for assigning their rights for Rabang 4, namely the 2.5 million ringgit, which represented their investment in Rabang 4. The plaintiff suffered this loss due to the defendant's breach of the assignment agreement and his unilateral dealings with DA Land. Following the defendant's breach, no investment in Rabang 4 could ever materialize. And so, the effect is that the decision of the Court of Appeal has been reversed insofar as the refund of the 23 million ringgit to the defendant, and the plaintiff can now recover its 2.5 million ringgit loss of investment. We now come to the landmark part of Lim Swee Choo. This is how the question was framed in the Federal Court. Question 4. Whether the true test of a total or failure of consideration is as stated by the House of Lords in Skotsnia Guzanska and Latvian Shipping Company per Lord Goff of whether the promissor has performed any part of the contractual duties in respect of which payment is due, and not the test of, quote, whether the party in default has failed to perform his promise in its entirety as stipulated by the Federal Court in Berjaya Times Square and M. Concept, Sejaran Berhad. Question 5. Whether the case of Berjaya Times Square relied on by the Court of Appeal has wrongfully conflated the right of rescission of a contract with the right to seek restitution on monies paid and received, and is therefore not truly classifiable as an authority for the doctrine of restitution based on a total failure of consideration. The Federal Court answered both questions unanimously in the affirmative. To answer question 4 of the Federal Court, let us consider what the case of Skotsnia Guzanska and Latvian Shipping Company was about. Skotsnia Guzanska was a shipyard in Poland. They were commissioned by various companies, including Lat Reefers Incorporated, to build 3 vessels with an option to build 3 additional vessels, which Lat Reefers exercised. Lat Reefers was wholly owned by Latvian Shipping Company. Payment was to be made according to 4 payment milestones. The first is a 5% within 7 banking days after receipt by the buyers of a bank guarantee to be furnished by the yard. The second, a 20% within 5 banking days after the yard had given notice to the buyers of keel laying, which in the shipping vernacular means the joining of the first and second section of a ship hull at dock. Third, 25% within 5 banking days after the yard had given notice to the buyers of the successful launching of the vessel, and 4, balance of the 50% upon delivery of the vessel. As Skotsnia was laying the keel for the first 2 vessels, Lat Reefers gave notice to reduce the purchase price of the vessel and to defer some of the payments. The reason cited was a downturn in the industry. This was rejected by Skotsnia. The second tranche of installment was due for the first 2 vessels when the keel laying was complete. But Lat Reefers defaulted and Skotsnia served a notice to rescind the contracts for vessel 1 and 2. What happened thereafter became the point of contention. Scottsdale attempted to take advantage of that first breach of vessels 1 and 2 in order to trigger a default for the remaining vessels 3 to 6. They did so by renumbering the kills that had been originally laid for vessels 1 and 2 as vessels 3 and 4. They then followed through by serving fresh notices for the kill laying for vessels 3 and 4. When lead reefers failed to make payment, they gave similar notices to rescind the contract for vessels 3 and 4. They did the same maneuvers again for vessels 5 and 6. Predictably, the second installments were not paid, and again the yard gave notice of rescission for both contracts 5 and 6. Scottsdale sued lead reefers. The High Court allowed Scottsdale's claim for vessels 1 and 2 but dismissed their claim for vessels 3 to 6. This was affirmed again by the Court of Appeal. At the House of Lords, lead reefers sought to overturn the decision by saying that there was a total failure of consideration because at no point in the contract did they receive any benefit of the contract. It was Mr. Glennie's submission that there would be, in such circumstance, have been a total failure of consideration because the buyers would have received nothing under the contract, no property in the vessel or any part of it having been transferred to them. The relevant question was, had the buyers received the benefit of any part on that which they had bargained for? The answer to that question must be in the negative, because any time or money spent by the yard in building the keels inured solely for the benefit of the yard in whom the property remained. The situation was therefore different from that under an ordinary building contract where the building as it is erected belongs to the building owner as the owner of the land on which it is built. And this is what Law of God said with regards to lead reefers' submission. I find myself to be in agreement with Mr. Kodara's submission on this point. I start from the position that a failure of consideration does not depend upon the question whether the promisee has or has not received anything under the contract, like, for example, the property in the ships being built under contracts 1 and 2 in the present case. In truth, the test is not whether the promisee has received a specific benefit, but rather whether the promiser has performed any part of the contractual duties in respect of which payment is due. Coming back to Lim Swee Choo, the federal court took notice the difference in the expression in the House of Lords in Scottsdale, where the test was whether the promisor has performed any part of the contractual duties in respect of which payment is due, as opposed to the federal court in Berjaya Times Square, which formulated the test as whether the party in default has performed his promise in its entirety, to which the federal court preferred and held the earlier to be good law. This clarification by the federal court is crucial and is very much welcome. This is because following the decision of Berjaya Times Square, another case appeared before the federal court in 2011. That was the case of Damansara Realty Berhad and Bungsar Hill Holdings Sudra Berhad. In that case, the federal court created a different test from the failure to perform the promise in its entirety developed by Berjaya Times Square. These are the facts of Damansara Realty. Bungsar Hill Holdings was the landowner of a huge plot of land in Damansara Heights. They entered into a property development agreement which gave Damansara Realty Berhad the rights to develop the land for a period of 15 years commencing the 4th of July 1994, meaning the agreement would expire on the 5th of July 2009. After executing the agreement, Damansara Realty did not take any steps or effort to commence development. Then, on the 25th of October 2007, which was 13 and a half years into the agreement, Bungsar Hill issued a notice of termination to Damansara Realty. They cited the latest failure to develop the land as a material breach of the agreement. It also said that the agreement would effectively terminate on the 27th November 2007. It was not disputed that upon receiving the notice of termination, Damansara Realty suddenly woke up and took some steps towards initiating the development works. By the time this case appeared before the federal court, Berjaya Times Square was decided less than 2 years before. Damansara Realty sought to rely on Berjaya Times Square, arguing that Bungsar Hill could not rescind the agreement as there was no total failure of consideration since Damansara Realty did not fail to perform its obligation under the agreement in its entirety. Though the federal court dismissed the appeal on other grounds, it did so consider Berjaya Times Square, and this is what it says in Obiter. In Berjaya Times Square Sendirian Berhad, it was held as long as some work has been done indicating that the development or construction had commenced, there would be no total failure of consideration because the promise had been performed, although not in its entirety. On the facts of that case, the decision may be supportable, but we do not agree with the stand that there can be no total failure of consideration so long as part of the promise has been fulfilled. In our view, whether or not there has been a total failure of consideration is a question of fact which must be resolved by looking at the circumstances of the case. Each case has its own peculiar facts. No two cases can be said to be identical, although they may be similar. We are inclined to take the view that minimal works such as getting development permission orders or taking possession over the land for development purposes may not, in most instances, fall on the same site as Berjaya Times Square Sdn Bhd. This is simply because such an interpretation does not make commercial sense. What good is a mere foundation of an office building to a company? In such circumstances, it must be taken as if the promise had not been fulfilled in its entirety. In fact, in Berjaya Times Square Sdn Bhd, it did not rule as wrong the conclusion in the cases which allowed termination of the respective contracts on the ground that there was total failure to complete the contractual works. As such, the principle should therefore be this: there is a total failure of consideration and a failure to perform the promise in its entirety, where a reasonable and commercially sensible man will look upon the project having little or no value at all. If the reasonable and commercially sensible man sees the performance of the contract of having some value, it should be taken that there has been no total failure of consideration, and accordingly the promise has been performed in part. In the earlier instance, there is a right to terminate the contract, but not in the latter instance. Fortunately, the federal court in Lim Swee Choo decided to address its decision in Damansara Realty as well. And this is what it says. In Damansara Realty, this court understood Berjaya Times Square as stating that as long as some work has been done, there would be no total failure of consideration because the promise has been performed, albeit not in its entirety. However, the Obiter in Damansara Realty went on to state that total failure of consideration could still occur even if part of the promise has been performed, depending on whether such performance, viewed objectively from the perspective of a reasonable and commercially sensible man, is of a nature that has some value in the context of the agreement between the parties. This can be seen in paragraphs 58, 59, and 60 of the judgment in Damansara Realty. In our considered view, the test in all these cases is at variance. Further analysis of the tests for total failure of consideration will be undertaken when we address the relevant questions. So, with that, the federal court in Lim Swee Choo have clarified the law on this. Damansara Realty in Obiter and Berjaya Times Square, insofar as it relates to the test of total failure of consideration, are no longer considered good law. And so, following Lim Swee Choo, the test for total failure of consideration for the purposes of restitution and not termination is now this: whether the promisor has performed any part of his obligation of which the payment is due following Scotsnian Kazantzaka. It is no longer whether the promisor has failed to perform his obligation in its entirety, as stated in Berjaya Times Square, and it is not whether a reasonable and commercially sensible man will look upon the performance as having little or no value at all, as decided in Damansara Realty. And finally, on to question 5. This is where the federal court took its task to clear the air in respect of the decision in Berjaya Times Square on the issue of termination versus a claim of restitution. This court in Berjaya Times Square conflated the right to terminate a contract for breach with the right to claim restitution, recasting both as a common law right to rescind in order to justify reading the concept of total failure of consideration into the phrase "his promise in its entirety" in section 40. This can be seen in paragraphs 12 to 24 of the judgment. However, in our perusal, the respondent in Berjaya Times Square did not ground his claim on the basis of restitution, but rather on termination of contract for late delivery and for order to recover purchase price. In our considered view, the right to terminate a contract for repudiation under Section 40 does not depend on the question whether or not there is a total failure of consideration, but rather the test is whether the action of the party in default would lead a reasonable person to conclude that he no longer intends to be bound by the contract. To our mind, the notion of total failure of consideration should not form the interpretation of Section 40. Only after resolving the issue of termination under Section 40 does it become relevant to consider whether the innocent party may bring an action in restitution for money had and received, and in this respect, whether there has been a total failure of consideration. It seems to us that the doctrine of total failure of consideration is confined to cases concerning the availability of restitutionary relief, rather than being used to determine whether the innocent party has a right to terminate a contract for breach and to claim damages for breach. Therefore, in our considered view, the cause of action in contract for fundamental breach giving rise to a right to terminate is separate and independent from the cause of action in restitution for the recovery of monies where there has been a total failure of consideration. The conflation of principles for breach of contract and restitution into a single operative construct under Section 40, read together with Section 51 sub 1, is therefore an erroneous judicial development in Berjaya Times Square at the expense of legal certainty. So now, with Lim Swee Choo's decision, there is now clarity on the following principles. The test for a right to terminate a contract for repudiation under Section 40 of the Contracts Act 1950 or common law is not whether there is a total failure of consideration, as per Berjaya Times Square, and where a party is seeking restitution for monies had and received, only then does the test of total failure of consideration applies. And as stated above, it is not whether the promisor has failed to perform his obligation in its entirety, as Berjaya Times Square said. It is not whether a reasonable and commercially sensible person would look upon the performance as having little or no value at all, as decided in Damansara Realty. It is whether the promisor has performed any part of his obligations which the performance is due, as stated in Scottsdale Gazanska. A little interesting fact about this entire episode: the judgment in the federal court in Berjaya Times Square was written by the late and eminent Justice Gopal Sri Ram. His lordship retired from the bench in 2010. In the landowner against the defendant suits, he was the counsel for the defendant, at least according to records at the High Court stage. As most remember, Justice Gopal Sri Ram passed away in January of 2023. He was, in my mind, one of the greatest, if not the singular jurist of our time in Malaysia, and I'm sure many will regard him as the same. I can only imagine, had he been the counsel for the defendant at the Apex Court when Lim Swee Choo was heard, what an interesting day in court it would have been to hear his take on the decision of Berjaya Times Square.